And welcome everyone. With me today is Genene Dunn from Hunsberger Dunn. She is a managing partner for Hunsberger Dunn, and she's going to share with us hopefully everything she knows in a short 40 minutes, and we'll leave a few moments at the end for questions and answers. Genene, let's blow through this early warm-up stuff so we can get right into the content for everybody. I know a lot are joining us today on lunch. So if you want to go ahead and start moving on the slides here, we'll jump right in to the content. Quick disclosure, give us a call if you need a copy of our ADV. I'm Cary Facer, one of the founding partners of Warren Street Wealth Advisors, and I've been referring clients to Hunsberger Dunn for close to 10 years now. And there is no conflict of interest here, meaning Genene and I do not work together. I'm not paying her to be here. She's not paying me to promote her. We have her here because she's been a great resource for our clients, and we thought it'd be a really nice thing to share all the questions we get. So Genene, let's get right into this. Oh yeah, we do planning investments. Everybody knows that. About me, I mentioned already, I started back in 2007, a founding partner at Warren Street, and Jen, who helped us with this deck. Thanks for adding that fun fact. Yes, I can run a mile sub 6 minutes.
All right.
Genene, yeah, please tell us about your team and yourself.
Yeah, so I'm Genene Dunn, and I'm the partner here at Hunsberger Dunn. That there is my partner, Don Hunsberger. He's been doing estate planning for 40 years now, and I have been with Don since 2008. So I've been in this field and handling this process for 14 years now. And we formed the partnership in 2016, where me and Don became partners, and we have five support staff to help assist our clients through the entire process. So what we do in the estate planning realm and here at our firm is we do business planning. And what that typically means for us is for clients of ours that usually have a family business, and we make sure that that's incorporated into their estate plan. What's going to happen when the main people in that business pass away or retire? Are there other family members that are in the business or not in the business? What does that look like? Do we own the properties that the business is on? Are all of our business records up to date? All of those kinds of things. A lot of discussion that centers around our clients that are business owners as well. And then we do estate planning. We do personalized estate plan for all of our clients, depending on their family situation, their asset situation, the tax environment, currently and anticipated, all of those kinds of things. We also do probate here. Probate typically is when somebody doesn't have a plan in place and they pass away and have assets that need to go through the probate court system. But we're usually doing everything within our power to avoid the probate court system. And it's very avoidable if things are done properly. But for those who do not plan appropriately and never had an attorney to help them through the process during their lifetime and their assets do need to go through probate, we handle tons of probate cases here as well. And then we also do trust administration. So that is when somebody did have an estate plan and they passed away, and then their family typically is having to go through the process of what's required legally and the family to get those assets all taken care of and eventually distributed to whoever the decedent said. So a little bit about me. Like I mentioned, I joined the industry in 2008. I am the managing partner here at Hunsberger Dunn. My partner Don is nearing retirement. He's taken a step back, so I am really the one person controlling the firm and managing the firm. He's still involved, but minimally these days, as he takes a bigger step towards retirement and just having grandkid time. So like I mentioned, I do have an associate attorney, and I have support staff as well to help us through all of these processes and make sure that everybody's getting what they need to get done. I'm also a mom. I have a 7-year-old girl and a 5-year-old boy. I've been married for 9 years. We also have an estate plan, so we practice what we preach. But in good kind, we signed our estate planning documents the night before we went on a trip to Europe. So I know how that goes, and we're very sensitive to when these things come to light for people. Okay, so starting off with the basic estate plan. So these are the documents that come with the run-of-the-mill every estate plan that most people who live in California need. So there are thresholds that would trigger the probate process. And that is typically if you own real property in California that's worth $55,000 or more, or total assets that are worth $185,000 or more. So that's where I'm usually starting. There's things we can do with accounts. Property is usually the biggest factor that trigger people needing a trust as opposed to a typical will. When people think, I need to get my affairs in order, I need to get my will done. Yes, a will, you can say what happens to your assets when you pass away. But in California, if you had just a will and meet those thresholds, your assets would have to go through the probate process to get to your beneficiaries that you have in your will. So if we meet those thresholds, then we're usually talking about doing a trust as opposed to just a will, because if we have those assets in a trust, you still get to say who gets your assets and any restrictions that you want in there in whatever fashion you want. But as long as those assets are in your trust, they are protected from the probate process. No probate court process whatsoever after you pass away, as long as your assets are all properly in a trust. So that's why we're usually doing trusts, and why they're very common in California, is because the probate process is a long process and it's a very expensive process in California. When we have a trust, we still do wills, and the wills just become what's called pour-over wills. And what that means is that any assets that would be subject to the will pour into the trust, and the trust is the beneficiary of your will. For most clients, we're usually telling them that the will is pretty inconsequential. We're probably never going to really be using the will because the trust is going to be the ruling instrument, and the will is there as kind of a backup plan in case there's any assets that for some reason get left outside of the trust accidentally, or if there's a specific purpose. But wills are also where people would nominate guardians for any children that are under 18. If you have children under 18, you would nominate guardians in your will, where you would say, this is who would raise my kids if both parents passed away before the kids turned 18. So for clients that have minor children, the wills do matter, but most of the time they're as more of a backup plan. The trust is the ruling instrument. And so those are the documents that are after you pass away, what's going to happen with your assets typically. But then just as importantly, in my opinion, while you're still living, if somebody needed to assist you financially or medically, who that would be, what some of those major decisions you would want made, those are what goes into the power of attorney and the advanced healthcare directive here in California. So those documents, in my opinion, are just as important as a trust or a will, because if you reach a position where you have Alzheimer's or something like that, where you can't legally sign documents anymore, and somebody is needing to assist you to make sure that you're getting proper care and that your proper care is adequately paid for, if we don't already have a power of attorney and a healthcare directive in place, then usually your family members would have to go through, again, a probate court process of conservatorship to get the proper authorities that they need to make sure that you're properly cared for and that they have access to funds to pay for that care. And the conservatorship process is a very long process and a very expensive process that brings all of your assets subject to the court's jurisdiction. We have to answer to the court with everything, and that goes on as long as you're living. So the conservatorship process, another probate part that is just very easily avoidable and very expensive when we unfortunately have to go through it. So the power of attorney and the healthcare directive, 95% of the time, can cover any potential issues that would otherwise have to go through the probate court process of handling somebody's affairs while they're still living. And then the last part that we do is actually funding your trust. So that means going through your assets, making sure that everything is properly titled in trust or has direct beneficiaries on there for some accounts that's appropriate. So we make sure that all of your assets either get transferred in. Here at our office, we actually do the deeds to transfer your real property into the trust. We get it recorded, everything, so that we know that the property, by the time we're done with your estate plan, is properly recorded into your trust, because that's a huge deal. And then we talk to you about all your other assets. Typically, what's going into a typical living trust would be your checking, savings, and brokerage accounts. Typically, we're not putting retirement accounts in there. So IRAs, 401ks, annuities, life insurance, those all typically would have their own direct beneficiaries on those accounts. and backup beneficiaries, and that's usually preferable depending on your situation. Sometimes when people have minor children, we'll put the trust as a contingent beneficiary on those accounts, just life insurance especially, so that we can control how those funds would go to younger children. But if we have very responsible beneficiaries who are old enough and responsible enough, typically they're going to go directly on those accounts so they don't have to go through the trust. But those are all things that we discuss with every client of what assets do we have and what's proper and how those should be transferred to the next generation in those kinds of different situations. All right, so talking about the living trust a little bit more, the main point is usually avoiding probate, making sure that your wishes are in writing and concrete and going to be effective and not have to go through the court process to get to whoever you have in there as your beneficiaries. So those are those exact thresholds. Do you own real property in 2022 that's worth $61,500 or more? If you don't, then we go to, are your total assets worth more than $184,500 or more? And we talk about what does that look like? What kind of assets are they? How are they titled? What's going on with them? If the answer is no to that we don't have any vulnerable assets worth more than that, then you may not need a living trust. That's where I start with all of my clients. Do we meet these thresholds? If the answer is yes to either of those questions, then that's usually where we go into the discussion of the living trust. Again, usually the real property is the big trigger for doing a trust, especially in California. People own their primary residence. You're going to be most likely worth more than $61,500. That is gross. It does not matter what the mortgage is against your property. I get clients all the time that say, well, me and the bank own my property. Well, the way probate works is it goes on the gross value. What would it sell for? Even if you have a huge mortgage against it, even if you're underwater, it doesn't matter. What goes is the fair market value. What could that sell for on the market? That's what triggers probate. And again, a lot of the times the main asset that we're dealing with that goes into the trust. And funding your trust is a really big deal. Like I mentioned briefly, what goes into the trust, all real property should be in the trust. Across the board, any property, real property that you own should be in your trust. In the United States, in the entire country, no matter what state it's in, it can be in your trust. If you live here in California and have a California trust, your out-of-state property should still be in your trust. International assets are a little bit different and require a whole different discussion, but any real property here held in the US needs to be in your trust, because then that means that we can administer it here and it doesn't have to go through probate in any state as long as it's in your trust. Again, all business interests should be owned by your trust. We have a lot of clients who are business owners and have smaller businesses typically, or maybe own an interest in a different business. And it's very easy to make sure that each individual's business is properly owned by their trust. It's not really that complicated, and it doesn't mess with the business structure itself. All that we do is make sure that the individual's interest is properly either assigned to the trust or on the business records itself, showing them as owned as trustees of their trust. Again, retirement and life insurance generally do not go into your trust. So those will typically have their own direct beneficiaries on there, and it's better for the beneficiaries to inherit directly from those accounts, depending on the situation. We talk about the situation, what's going on with who that would eventually go to, and is that appropriate? And as long as everybody's old enough and responsible enough to get those assets, it's usually tax beneficial for them to get it directly from the account. They have more decisions on what they can do with the account, and most different things that those generally do not go into a trust. You can put pay on death beneficiaries on really almost any kind of account. And so definitely, again, retirement and life insurance, when you're setting those up, typically those automatically, you're talking about what beneficiaries going on those accounts as well. Sometimes even checking and savings and brokerage accounts can have pay on death beneficiaries as well. If you have pay on death beneficiaries on an account, that will protect the account from probate. And we talk about that with our clients as well. So even if you have real property that's in a trust, it doesn't mean that every single asset you have needs to go into the trust. And again, why funding is such a huge part of the discussion. But generally, we do say that your trust needs some kind of liquidity. So we are usually telling our clients, you need at least one account that is going to somehow get to your trust or be in your trust. Because when your trustee is trying to handle your affairs after you've passed, it costs money. It costs money to do some of those things. We got to file final tax returns, get on the account, maybe clean up a property, do some things to make sure we sell a property, all these different things that come into play that cost some money, not a ton of money, but cost some money. And we need some liquidity in that trust to be able to support the trustee to get their job done appropriately. A lot of my clients recently have been able to take their checking or savings account and put the trust as the pay on death beneficiary on those accounts. It's been a great way for this to get done because sometimes the banks do make it a little bit difficult to transfer your assets into your trust. And so this way, it's a bit of best of both worlds in that your checking and savings accounts can stay the same, but also are protected from probate, are going to provide liquidity to your trust if you have the trust as the pay on death beneficiary. I know Schools First in particular is very good about getting this done for our clients. They know exactly which accounts to put the trust as the pay on death beneficiary on. It's very quick for our clients and it's not a big headache. And we know the proper accounts are going to go flow through into that trust. So those are just things that we talk about and think about when we're talking about what assets go in the trust. In my situation, what should or should not go into the trust. So when I talk about probate being a long and expensive process, this is kind of a quick reference chart to see what I mean. So the probate estate value is there on the left column, and that again is gross. So if we have a property, the one I have bolded there is $1 million because most properties that we're seeing, especially in Orange County, are going to be at least at the 1 million mark, you know, sometimes above, sometimes below, but that's the more common roundabout figure that we're seeing these days. So if you have a property that's worth $1 million, even if we have an $800,000 mortgage on this property, the cost that it's going to be to get through probate are $46,000. That is set by law. It's set by statute. The law says what the attorney gets paid for handling the probate and what the executor gets paid for also handling the asset through the probate process. There's also some court fees that are around a couple $1,000 usually that are associated with it. But by law, that's what it says goes to the attorney and the executor. And again, this is if we have assets that are going through the probate court system. If we don't, and we have assets in a trust, those fees immediately gone. There's still some cost to get through administration, but it's nothing like this. And again, the waiting period, the time that it takes to get through probate is at least a year, typically, sometimes multiple years, depending on the situation and the court's backlog and are we in a pandemic, those kinds of things. Your power of attorney that I talked about, you have financial and medical. Here in California, your medical is called an advanced healthcare directive. If you couldn't handle your own affairs, who would do it? Where is their authority to do so? A lot of times people think, oh, my kids are just going to take care of me, and they probably are. That's probably accurate. But if we're in a situation, which I see a lot, is maybe we don't even have an Alzheimer's or dementia diagnosis, but mom or dad, because I don't have too many issues with spouses, but a lot of times it'll be mom or dad are starting to forget things here and there, and bills are forgetting to get paid here and there. They're not necessarily incapacitated, but they need some assistance, and kids are trying to make sure that everything is being properly paid or that aren't being double paid, or there's not too much money going out to different causes that mom and dad have never given money to in the past. Those are all things that can be helped with a power of attorney. And also on the medical end, you know, mom and dad are starting to forget what the doctor's saying, but you can't, the kids can't call the doctor and just get a rundown of what happened, what's going on, and everything okay. It's not easy to get that done. That's where the healthcare directive comes into play. Those kinds of things that people kind of think are going to be automatic and easy to handle aren't always. But if we have these documents in place in case that comes up, then they are very easy to handle and easy to deal with. Again, if we don't have those and we're in that situation where somebody can't sign a legal document, the only option the family has is to get a conservatorship. We do them here. They are not fun. They are not an automatic thing that somebody just files a petition, you get a conservatorship. It's an entire process. The law has recently changed on it, making it an even more difficult process for good reasons. But now it is quite an involved process. It's very expensive and takes a long time. So we also do a lot of custom planning with our trust. It's not just everybody gets the same trust template for their situation, no matter what they have going on. There's a lot of different things that you can do within a trust. One of the main things that we talk about with our clients, especially those who've done trust a long time ago, but maybe need to update things, is do we have an AB trust? It used to be across the board for all married couples, everybody got an AB trust, and that was appropriate. Even when I started doing this, the estate tax exemption was below $1 million. What that meant was that if you own assets that are worth $1 million, you would be subject to paying an estate tax to the federal government when you died. And that is literally just a tax for dying, and your assets, if they're worth more than $1 million, you paid 40% of anything over that threshold to the government just for having assets. So that estate tax exemption now has gone way up. So the way that we would avoid that tax or help minimize that tax would be creating this AB trust, to where when one spouse passed, the trust would split into two trusts, and we can lower that value, lower that potential estate tax that we're paying. But now in 2022, the estate tax exemption is $12 million per person, which means that if we have a married couple, they wouldn't be subject to an estate tax unless they were worth more than $24 million. Now that is expected to go down in 2026, but still to 5.5 million per person. So for a married couple, typically we are asking, are you around the 11 million mark or more? And that's where we're kind of doing our tax planning. But at the end of the day, even the 5.5 million does not apply to many Americans. It's a little skewed here in Orange County, but essentially for married couples that may not be anywhere near that 11 million mark, they don't necessarily need an AB trust, and that adds this complication to their trust documents and to the survivor's life, really, that to avoid taxes. We want complication. We're down. Everybody's okay with complication as long as we're avoiding taxes. Everybody's okay with it. But if there's no tax that we're going to be subject to, then it may not be worth the complication. And that is a whole discussion that needs to be had of how should we structure this trust? Do we need an AB trust? It shouldn't be automatic these days. It should be a whole conversation. Another thing we talk about is, do we have any children or beneficiaries with special needs? There's a lot of things that we can do, but if kids or any beneficiaries have special needs and are getting government benefits of any kind, including Medi-Cal, because health insurance under Medi-Cal is a big cost usually, and if they lose that medical coverage because they inherit assets, that can be a huge deal. There's things that we can do to where that child or that beneficiary can still get their share. And we do a special needs trust typically of some sort, or life estate, something of the sort, to where they can still get a benefit from their inheritance, and it will not affect their benefit from the government for whatever they need medically or anything of the sort. We also do a lot of multi-generational planning. We also do litigation in our office, so we see what causes problems in people fighting trusts or trustees. So this is definitely a big conversation when people think they want to structure things to not only go to their kids, but make sure it's being passed down, or make sure we're protecting from spouses. That's a huge one as well. There's a lot that goes into that. There are things that we can do. We are a little bit limited here in California, but there are things that we can do, and as long as it's appropriate. And in those structures, we will also tell our clients what it means, and that it possibly could open the door to more court proceedings, but not always. And at the end of the day, every client is the controller over their assets and their plan. If they want to do multi-generational planning, we can do it, and we can structure it appropriately how they want it done. We also deal with a lot, if you have larger estates, that's typically where we are going into, how are we going to pay out to your children? Are you comfortable with your 18-year-old getting $3 million? A lot of times what people don't think about when I'm talking with them is, you know, if they may have a term life insurance policy that's worth $1 million each, and that's if they were to pass in the next 20 years, then that's another $2 million that would potentially be going to their kids. And are they comfortable with, depending on the age of their kids, are you comfortable with, if you have two kids, with your 21-year-old getting $1 million? Most of the time the answer is no. And usually we can put in the trust, how is that life insurance going to get paid to the trust? And then also in that trust, how is it going to get paid out to the kids? Are we going to tier it? We can do multiple payments. We can say it gets paid over a period of 10 years, no matter what age they are. We can say it gets paid at a little bit at this age and then more at that age and then the next at that age, all of those different things. There's so many things you can do on making sure that that payout is structured. We can also do life estates. We have a lot where there's concerns about, well, our kids are fine, but they're not really great with money and we're afraid with what they're going to do with the money. So maybe we're going to keep it in trust for their benefit. A lot of the time we're doing life estates when there's concern about a spouse of a child, and our child is fine, but their spouse is going to be in their ear, and that money may go towards other things that our kids may not even necessarily want, but they convinced to do. Well, that is sometimes answered with the life estate, to where they don't get the money outright. It stays in trust for their benefit, and there's some restrictions there to where they can't just spend it on whatever they want or however they want, or maybe they can, but it's a little bit harder, or it at least presents this a bit of an obstacle for that spouse to say, let's just spend all the money on X, Y, or Z. Sometimes that's a concern, and there's ways we can deal with that. And also, adult dependent children it's a big one as well. A lot of the things that we see causing problems is kids that are still living with their parents, even though they are adults themselves. And sometimes, it goes both ways. We see often that there's a child who moves in with their parents purely because their parents need assistance and they need to make sure they're okay. So they give up a lot of their personal life to move in with mom or dad and make sure that they're okay and there to take care of them, and as opposed to hiring caregivers, to having strangers take care of them, or not having to pay for caregivers to take care of them. And if that's the situation, we talk to them about what does that mean? Because technically when the parents pass away, well, that child is now sitting on an asset that is supposed to be split with other kids. Do we want to give them a certain amount of time before they're required to move out or start paying fair market value rent? Or on the other end, we get the adult children who have been there their whole life, have never really made their own money, and have always just had mom and dad take care of them. Okay, that's all fine and dandy, but what are we going to do when mom and dad are gone and now we have siblings who are not willing to use their own money or their inheritance to take care of them? What are we going to do? What is the plan for that? We talk about that a lot because we're seeing that more and more these days. And we're also seeing that be an issue in court that we have a child who will not move out of the property, and maybe who's in charge of the property, but is sitting on the asset. Maybe they're the trustee and nobody else is able to get anything done, and they're becoming impatient. Usually we're seeing that impatient at about the 6-month mark after somebody passed, that the others start to get a little impatient of what's going on here. So there's things we can structure in that trust to hopefully avoid those problems. Absolutely. So I mentioned trust administration. What that is essentially the process of what happens when somebody passes away and they do have a trust, and they do have assets in a trust that go to specific people when they pass away. The trustee in that situation is the person who is named as in charge of those assets when the decedent passes away. And there are a lot of things that are required of the trustee that most people don't know about. And so that is why we would suggest that the trustee does have an attorney, because being the trustee comes with a lot of liability as well. And the law does have a few requirements of what that trustee has to do. And if the trustee is not aware of what they're supposed to do, then they may not do it, and they can still get in trouble for not doing it, even if they were not aware of it. So even in the happiest family, we absolutely do recommend that the trustees get an attorney to help them through the process, make sure that all of the notices are properly given as required, make sure that they properly get to take over all of the assets and get through the process of paying the final bills, filing the final tax return, preserving the assets appropriately to eventually get distributed to the beneficiaries. It does come with a cost. It's just nothing like probate. Trustees also get to take compensation. Sometimes it can be quite an involved job, not always, but typically the compensation is either at an hourly rate for the trustees tracking their time and getting paid for the time that they've spent. But again, I've been here for 14 years and going through this process. Not once have I seen a trustee track their time and get paid hourly. Typically, they take a flat fee, 1% of that total trust value. And that is the industry standard right now. And it's been that way for the 14 years that I've been involved. And I don't see it changing. Typically, it's 1% that the trustee gets of the total trust value, the assets that are in there. That gets taken at the end of the process. Not all trustees take it. if it's a child that's just going through the motions and getting everything distributed, most of the time, oftentimes they waive that. They don't take compensation for it. It's taxable. Compensation is taxable. So that's sometimes the reason that they don't take it. They're going to get inheritance typically anyways, so they don't need another few $1,000s on top of that, those kinds of situations. The attorney typically gets paid hourly for whatever time goes into it, is what it costs. I would say the average cost of an administration for a happy family is around $2,500, maybe up to a $5,000 to get through all of those requirements. We do a flat fee for a happy family to make sure that everything goes through the process appropriately. We like the flat fee structure in that situation because we want everybody to be able to ask as many questions as they want through the process to make sure everybody feels heard and understood, and that they're not going to be on the clock every time that they're wondering what's going on or why we haven't gotten our money a month later. Is an often question we get. And what makes people fight? Across the board, it's sibling rivalry. The most thing I see is that it really has nothing to do with mom and dad. It has nothing to do with the assets. It has to do with the kids just having some issue with one another, and this is their outlet. And they're not having to keep it together for mom and dad anymore because mom and dad's not there. So across the board, that's the number one thing that we see, is that they just truly can't stand each other or have this bone to pick, and this is what they're choosing to go after it at. Sometimes, though, it's not that. Sometimes it's that the trustee is just doing nothing. They're not doing their job. They're just sitting on the assets. It's been a year since mom or dad died, and nothing's happened. I should be getting inheritance, right? What should I expect? A lot of times what we hear is that's not what mom or dad would have wanted. And that's a difficult one. Depends on the situation. Sometimes that's true. Sometimes mom and dad told every single sibling something different. So that can be difficult, but we hear that all the time. Another one that I mentioned before is that someone is living in the residence of the deceased. That is a huge issue. Again, I do personally think that can be fixed, if not at least somewhat addressed in the trust document itself, but it's not very common. And so then technically when someone passes away, anybody living in the property that doesn't own the property is supposed to be paying fair market value rent to that trust. And again, if we have some sibling rivalry there, we get siblings who are not patient about that. And sometimes beneficiaries just don't agree how the trustee is handling things. And a lot of the times beneficiaries can be unreasonable and think that they're supposed to get their full inheritance in 3 months and what's going on. And they don't understand that there's a lot of things that the trustee has to do before it gets to that point. So yeah, those are things that can typically happen to make them fight. We do also do court processes. Sometimes there's court processes when there is a trust as well. That doesn't mean that having a trust makes it completely immune to court. However, it makes it extremely less likely that there's going to be any court proceedings whatsoever. But what we see causing things to go through court a lot is when we have assets that are not in the trust. So for whatever reason, maybe mom and dad did a trust 30 years ago, and then they sold a property, bought a property, didn't put the new property in the trust, never looked at their trust again, and then they passed away and property's not in the trust. Well, typically that doesn't mean we have to go through the entire probate process, but we do have to have some kind of court petition to get a court order that property was supposed to be in the trust. It was mom and dad's intention that it be in the trust, and they just didn't do the proper paperwork to make that happen. So we do what's called a 17-200 or an 850 petition, where we ask the court to make this piece of property an asset of the trust. The cost for that, average cost, is $5,000 just to get that through the court. We're dealing with court, we're dealing with filings, we're dealing with notices. Unfortunately, that takes time and money. Where we have a deed that's never been put into the trust. We've had it before where there was a charitable beneficiary that went out of business, but technically sold to another charity. And could we prove that charity was now the new charity? They have a different tax ID number. And, that was something that ended up costing $25,000 to get sorted out in court. We were not in litigation on that. People were not fighting. We were purely just trying to figure out who's the proper charity to pay according to what this trust says. And in that particular case, the charities were heavily involved, which is what made it more expensive, because the other charities didn't want that charity to get paid. That charity that felt they were supposed to get paid wanted to make sure they were getting paid. So that's what made it a little bit more expensive. Business interests, if they're never put into a trust, then you have potential business partners that are fighting over what should go to the family or what shouldn't, what the value could be. That's a huge issue, is what the value is and how we're going to get that paid. And sometimes we just need to remove someone if they're not acting and somebody else is willing to step in and get things done, but they're named as a co-trustee as having equal power. Unfortunately, the only way we can effectively get rid of them is filing a court petition to make sure that they're removed, even if they want to be removed, but maybe they're not cooperating. We've been down that road before as well. Again, those are just kind of the quotes there. Mom would have never said that. I'm the one who took care of mom. That's a big one. Mom, I'm the one who took care of mom, mom wanted me to get everything because I was the one who was there. It's a huge issue that we see all of the time. And sometimes, yeah, that person does get a little bit more rewarded, but I will say across the board, usually that doesn't mean that parent doesn't want anybody else to get nothing. And if that's what the documents look like, then we're probably in court. And that's all that I had for you guys. Cary, I don't know if you have any thoughts or things that you wanted me to elaborate on through this presentation so far.
Yeah, I do. There's one big question, but while we're doing that, if anybody wants to ask a question, we have probably another 5-10 minutes that we can spend on this. You can either chat, just say I have a question, and we can unmute you. You won't come on video, but we can unmute you, and you can ask your question. Or if you want to type it in, we will address it there. So just a quick reminder, find the chat, enter your question there, or you can just say, I have a question, and myself or Jen, who's helping produce behind the scenes here, she will unmute you for your question. Genene, while we're waiting for that, I asked you this last week when we were getting ready for this presentation day, and thank you again for your time. That was excellent. Why, I've been in this business coming on, I'm starting my 16th year now. We started our careers at similar times. Why do you think everybody waits so long to do this?
Yeah, excellent question, and very, very common. So I think this is just something that everybody knows that they need to do, but it's easy to put off because there's nothing forcing them to do it. There's no law that says you have to have your affairs in order, you have to have a trust. It's like insurance that you're definitely going to use. So, but there's a law that's telling everybody that you have to have auto insurance or else you can't drive, or you're gonna get in big trouble if something happens and you don't have it. There's no law that says you have to have this insurance before you pass, or else your kids are going to be in really big trouble, or you're going to be in big trouble if you happen to not pass or something. But I think that's part of it. There's nothing forcing it. It's something that people oftentimes don't want to talk about, don't want to think about. But across the board, I've never spoken to somebody who said, nah, I don't need to do that. Everybody knows, yeah, I really should do that. I really do need to get that done. And it's something that's easy to put off. It's very common. We hear it all the time. Oh, I'm finally getting this done. I've been meaning to do this for years. Again, I think it's because it's a topic and because nobody's forcing them into it. The ones that get it done are those who have seen other people go through it. They've seen some kind of situation where a family friend of theirs or even a family member had to go through the court process or ended up in this huge problem with their family because there was nothing in writing, and they didn't know what mom or dad would have wanted because there was nothing in writing. And those are the ones that forced themselves to do it because they said, I don't want my family to go through that.
We do have a question that came in. I have a follow-up to that. It seems like, in the years we've been doing this, a lot of this work is really for the children. Have you seen in your practice where the children are actually the ones who pay for the expense of having an attorney and go through this process?
We have seen it where the kids are definitely trying to get their parents to get it done, and also pushing their parents to get it done, get it through the process. As far as actually paying for it, is a bit of an issue with attorneys and who our client is. For me personally, it depends on the family. If we have a super happy family and everyone's involved and the kids are willing to pay for it just to get mom and dad to do it, then it's no issue.
Right.
If there's a family where one kid may not be included or getting less, then we have to be a lot more careful about.
Right, because they're going to say, oh yeah, you're getting 70% of everything and you paid for this and it's your friend who's the attorney, etc.
Exactly, yeah. But in a very happy family, absolutely. We have seen that. We have seen it where the kids are helping and the kids are involved. And as long as all the kids are involved and all on the same board and everybody's being treated equally, then yes, that happens and it's fine.
Good. Okay, so we have a question here. Do you handle conduit trust and or accumulated trust? I'm not sure exactly, so you might need to help me here what that is.
Sure. So we handle a lot of different kinds of trusts, but I will say that the estate planning that we do is typically the run-of-the-mill estate plan. When we get more into the asset protection and people who are wanting different kinds of trusts to protect their assets from certain situations, typically we will refer those out because we do not specialize in asset protection. However, when people pass away and we have the different kinds of trusts, we will typically administer any kind of trust and also litigate any kind of trust depending on the situation. Hopefully that helps. It depends on the particular kind of situation and what those trusts are wanted for or what situation we're in.
So a follow-up question, a couple more, is one, a lot of the first time cases where, everyone's going through trying to figure out, if I have to spend, let's say it's 2,500 to $5,000, something like that to get all this done. And then they search and they find, a DIY service and it's $600 or $700. Mm-hmm. Two parts. One is the time it takes to complete this process for your average client, happy family, married, 2 kids, what is it? Is it 3 months? Is it 6 months? Is it 12? Assuming, right? I know you can get it done quick, but I would say average length of time it takes to complete a living trust.
Yeah, excellent question. I would say from the consultation where we're explaining what the documents are and their situation to the end, meaning their deeds are properly funded, everything's signed, and all the assets are in there, I'd say the average is about 6 months.
Okay.
But it does depend on the client. So, we start with the clients have to make a lot of decisions through this. And sometimes that's easy to do, sometimes it's not. So it depends on how easy those decisions are. And that requires a lot of conversation with us. Mm-hmm. And then once we draft the documents, we also have our clients look over them and we encourage them to ask any questions or have any changes they've, maybe thought about or changed their mind on or things like that. And we also offer a time where we sit down and go over the documents with their clients to make sure they do understand them or have all their questions answered before they eventually sign them. And so it depends. Every client's a little different. Some clients want to be as minimally involved with the attorney as they need to be. And then we have other clients that are across the board want to ask as many questions as they can because they have us. And it's flat fee. So encourage the questions, definitely. Mm-hmm. So I'd say the average is 6 months for the entire process, but some of them are very quick. Some of them take a lot longer, depending on their situation.
Yeah. Someone had asked, and I'm not exactly sure the point they were talking, but it was something we had mentioned. They said, yeah, that was my question. Is it only, it's only me and my husband. However, he has grown children. And I think she's asking about estate planning, but she says, is this really that important for us? And I would probably say even more important.
I would also say even more important because what we're talking about there is a blended family. And I do see that is another thing that I probably should include in there of what can cause things to go to court is that, dad would never have wanted all of our family assets to go to his wife, stepmom. We see that a lot, and maybe he did, in all honesty. And we can answer that with a trust. We can answer that with a trust of, if we have a family property that was in the family and husband's family for a long time, but wife lives there and we want to make sure that she continues to live there if dad dies first, then we can make that happen in a trust. So yeah, there's a lot of different things to consider, especially in a blended family. And that also would go into, do we split? Do we have community property assets or do we have some separate property assets? Those are all things that can be addressed through the trust and should be and need to be. Even if they're not completely blended and they treat their kids as kids of both of them, and there's no dispute that everything's going to go to wife, and then when wife passes, everything gets split equally among the kids. Yes, you still need it, because if you don't, those assets will have to go through the probate process, and your kids would end up, your assets would be paying that $30,000 to $50,000 through the probate process to get to them.
Yep. Genene, another question came in, and this is a good one. If we purchase a new home, when should we incorporate it into the living trust, at the start of the purchase or after completion?
Excellent question. So if you have a trust already and you're purchasing property, at some point through the purchase, they should be asking you how you want to take title. And I usually tell my clients, try to remember that you have a trust and tell them that you want it to be put directly into your trust. Now here at our office, that's considered an asset update. And we put your assets on your schedule of assets, which is technically an attachment to your trust. And we never charge our clients for asset updates. Because we do the administration and litigation, we see that not knowing where assets are, assets not being in the proper place is what can cost a lot of money and headache and potential litigation. We want to avoid that at all costs and encourage our clients to contact us when assets change. So it can easily be added to your schedule of assets. When you're going through the purchase, they can put the title directly in your trust through the purchase. However, even if you wanted to double check that, it would be after the purchase is complete. After the purchase is complete, the attorney can check title, make sure it's properly in the trust. If it's not, we can do a deed to put it properly in the trust.
Great. Can you go back one slide, because the follow-up question is, sorry, go to your contact information. How do people get a hold of you?
Sorry.
Maybe it's forward one.
Yeah.
Yeah, sorry, forward a slide. There you go. One more. Sorry, that's us.
Sorry.
There you go. Good. Yeah, so they said, okay, yeah, ready to make an appointment. So I don't see any more questions, and plus we want to keep this at 45 minutes. So I think we're good. Genene, thank you so much. That was incredible. We had a few people from our team join this call because we went through this last week. I shared how excited I was about it, and I wanted everybody to join. We have a lot of clients that were on here as well. I just want to tell you, thank you so much. You've been a huge resource for our clients and continue to be one. So I thank you for that. If anybody has any questions, Genene, what's the easiest way for them to get a hold of you to schedule a consultation?
Yeah, absolutely. Thank you for having me. I'm a huge advocate for education and getting people just at least get the information and decide what they want to do from there. And I'm always here to answer additional questions. I would say the easiest way would be to give my office a call, and they can schedule a time to make sure we connect. Perfect. Otherwise, you can email me, and my email is there, Genene@hunsbergerlaw.com. Those do eventually get answered, but if it's something that needs more immediate attention, definitely give us a call, because my staff is here. We're a small firm and ready to answer questions, ready to make sure that people get answers appropriately and timely and all that. And
I know location is always important for clients because we're local. I mean, obviously we have clients all over the country, but your office is in Tustin, and you also live in the Inland Empire. So you cover quite a bit of area there.
Yeah, absolutely. We're here in Tustin. We're off of Irvine and Newport, very close to you guys. We also have office in Riverside because I live in Corona. We also do a lot of clients all over Zoom, and then we facilitate signing because they do have to be notarized. So we do also offer Zooms and phone consults, and these days we're very versatile with whatever is needed.
Wonderful. Well, that is it. Thank you everybody for joining. Genene, thank you again for your time. I always appreciate it. And we'll talk to everybody soon.
Absolutely. Thank you.
Bye, everybody.